Good evening. For those who haven't had a chance to meet before, my name is Russ Periski. I'm the founder of Paradigm Education Group. And what we're going to do tonight is the second part of our Paradigm Taxpayer program. I'm going to assume a lot of you had an opportunity to watch our first part, which was You Have Options. And this part here is called Learning Your Options. What we're going to do is we're going to pick up from where the You Have Option video left off and move into the two employment options that you have. The first one was a contract of service. That is for employees, okay, where you work for someone. And the second one is contract for service, i.e. self-employed, where you work with someone. As we discussed in the previous intro, this whole course is based on the Westminster Principle. It is a principle that's named after a 1935 decision of the House of Lords in the Duke of Westminster case. And the principle is that a taxpayer can legally arrange his affairs to minimize the tax payable regardless of his motive. The principle is simply one aspect of the doctrine that taxpayers should be governed by the rule of law, preferably clear and certain laws. What we're going to look at first is an overview of learning your options. The first one we're going to look at areas fundamentals. It consists of some principles of interpretation. Now, principles of interpretation is a very broad, vast subject, but tonight we're just going to look at a few that you're going to need in relation to looking at some legislation. Okay? We're also going to look at doctrines of contract. Doctrines of contract are fundamental principles of law relative to your right to contract. Most of you here are employed, and then being employed, you're under an employment contract. For the most part, most of you are under an implied employment contract. You've never had a written contract relative to your employment. So we're going to look at your right to contract and some doctrines relative to that. Then we're going to spend a brief time looking at what is called the fourfold test. The fourfold test is what's used to determine whether you're under a contract of service or a contract for service. And it's a very interesting test to look at because of the evolution it's gone through over the years. Okay? Once we go through that, we're going to go into some relative legislation, some relative case law, and then a whole section on exercising your options. We're going to look at benefits and burdens. As with everything, every decision you make comes with benefits versus the burdens, and that's the decision you're going to have to make. Are you willing to incur additional burdens relative to the benefits? So we're going to explore that relative to exercising the options that you have. We're going to look at some administration, primarily the new paperwork if you choose the option to be self-employed. And we'll wrap it up with examining some sample documents. Now, just to put all the cards on the table, I'm not a lawyer and I'm not an accountant. Okay, so these sample documents are documents that I would draft for myself if I was choosing one of these options. Okay? So we're going to start off with principles of interpretation. To do that, we need to ask ourselves this question. Can words in a statute be interpreted by opinion? How many people here have ever read a piece of legislation, a statute? Okay? For the most part, we have now evolved in our society where the only thing we know about legislation is what someone told us it said. And we've never taken the step to actually read it ourselves. And then usually if we do that, we're very unaware of the principles of interpretation. And what we do is we adopt or we interject our opinions, our thoughts of what words mean. So in an answer to that question, can words in a statute be interpreted by opinion? The answer is no. You must follow the rules. And this isn't anything new. Statutes are totally different than any book you'll read. A book you will read and you will attach natural and ordinary meanings to the words you read to create a picture of the idea that's trying to be expressed. In statutes, there's a very defined process to walk through to try to extrapolate what's really called the intent of Parliament, or provincial level, the intent of the legislatures. In this book called Legal and Political Hermeneutics, here's a quote by Francis Lieber. Interpretation is not arbitrary. It must follow a defined set of rules. And that's what we're going to look at, is look at a couple of the defined rules so that we have armed with us as we get further on into today's presentation. We can draw back on them and see what role they play. Another principle of interpretation is relative to words themselves. This is very interesting. You know, in relation to reading a book, it's really up to you to input the meaning of a word the author chose to use. In statutes, it's a much harder job because what you're trying to do is input what was the intent of Parliament for using that word. And here's a great quote out of a book called Construction of Statutes by Dreegers, is second edition, 1983. It's from page 3. It goes, Lord Green said, "The method of construing statutes that I prefer is not to take particular words and attribute to them a sort of prima facie meaning which you may have to displace or modify. It is so to read the statute as a whole and ask oneself the question, in this statute, in this context, relating to this subject matter, what is the true meaning of the word?" And that is one principle which we're going to apply later on. So I hope you put that someplace in your mind so we can pull it back easy when we get there. Another one we're looking at is sort of an expansion on that, and it comes from a Supreme Court case called R versus McIntosh, 1995. Chief Justice Lamer, in paragraph 21, he goes, Dreger, referring to Dreegers, the author of Construction of Statutes, then reduced the principles to 5 steps of construction. Number 2 is the one we're primarily going to look at today. It goes, the words of the individual provisions to be applied to the particular case under consideration are then to be read in the grammatical and ordinary sense. Notice how it's not a period there. And that's one mistake a lot of people make, is they'll read that up to that point, put a period, and then walk around reading statutes in a grammatical and ordinary sense. But that's not where this quote ends. It goes on. It goes, grammatical and ordinary sense, in the light of the intention of Parliament embodied in the Act as a whole, the object of the Act, and the scheme of the Act. And if they are clear and unambiguous, and in harmony with that intention, object, and scheme, and with the general body of the law, that is the end. So I hope you see just by this one expression from the Supreme Court of the process, what needs to go to truly understand possibly what one word means, what Parliament intended for a word to mean. And I know a lot of this may feel a little bit out of a context as we're just starting this, but what I'm really trying to do is plant some seeds of ideas in your head so when we actually get to the point of actually needing to use them, they're not just fresh ideas. You've had time to process them a little bit. The next principle of interpretation we're going to look at is, again, from R versus McIntosh in 1995, and it's paragraph 21. It's talking about the approach to take in reading a statute. Chief Justice Lamer goes, there is certainly support for a contextual approach to statutory interpretation. Dreegers, in Construction of Statute, has stated the modern principle of contextual construction as follows at page 87. Today there is only one principle or approach, namely, the words of an act are to be read in their entire context and in their grammatical and ordinary sense, harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. Again, as we progress, that'll make a lot more sense because we're going to look at a piece of legislation where this principle alone you're going to have to apply to truly come to a conclusion yourself and see if the act is harmonious and the words that Parliament chose to made sense. Another one we're going to look at, again, it's from paragraph 26 of the same court case. Chief Justice Lamer goes on and he says, I would agree with Pierre de Côté's observation in his book, The Interpretation of Legislation in Canada, at page 231, that since the judge's task is to interpret the statute, not to create it, as a general rule, interpretation should not add to the terms of the law. That's a very important concept. What we tend to do is if we're even venture forth to read legislation, we sometimes have a tendency to add words to the statute because it pleases the objective we're trying to achieve. So we have to be aware of that. Even the Supreme Court says they can't do it. So we have to say, well, where do we get the right to do it? He goes on to say, legislation is deemed to be well drafted and to express completely what the legislators wanted to say. Where this will come into play is, as we're looking at this piece of legislation, we have to look at it from that perspective. If there are no words in there that others would like in there, we can, based on this principle, assume that the legislature is well drafted and it expresses completely what the legislator wanted to say. Okay, so now we're going to move on to a few doctrines of contract. This here is a legal definition of what a contract is. It comes out of Canadian Law Dictionary, 4th edition. It says contract. A contract is a legally recognized agreement between two or more persons giving rise to obligations that may be enforced in the courts. By such an agreement, the parties not only restrict their present or future freedom to act by the limitations imposed upon themselves by the agreement, they are creating a set of legal rules binding as regards to themselves and only themselves. I hope by this definition you can start realizing the power of your right to contract, the power of a contract. When you enter into an agreement, whether it's written or implied, you have bound yourself. So I hope this shows it's very important to maybe explore this area, this doctrine of contracts, to see how powerful that right is. The first doctrine we're going to look at is a doctrine called the privity of contract. It's a doctrine whereby one can enforce contractual rights against another only if one was a party to the contract. Under the general doctrine of privity of contract, no one who is not an original party to a contract is entitled to seek to enforce the terms of the contract or is bound by any of its provisions. So as you see, your contracts is that it's effectively private legislation is one way of looking at it. It's a set of legal rules you've imposed upon yourself and the other parties to act in accordance. And the roles of the court is to come in, if there's a dispute within that contract, is to come in and try to figure out what the true meaning and the true intention of the parties were involved to try to find the balance of what was trying to be expressed in that contract. The other doctrine that we're going to look at is the doctrine of freedom of contract. It's the abilities of parties to agree to the most advantageous bargain between them without interference from the courts. You see how important that is? That is the right and the power that you have to enter in that contract. It's saying here, you don't have to run to a court and say, hey, can I enter into this agreement? Now, there are a few limitations if the contract's unconscionable and elements like that, but for the most part, if everybody's acting in fair and with integrity and with the objective to accomplish a balanced outcome, going to the court is an irrelevancy. Okay. In the 18th century, there was little restriction placed on this freedom, the philosophy being that men could pursue their interests in the way they saw fit, and the duty of law was merely to give effect to the intentions of the party. So we see the role the court plays relative to a contractual dispute. The court is not there to modify your contract, it's to try to give effect to the intentions of the party relative to the terms of the contract. For the most part, a lot of people who enter into agreements, they don't spend the time to truly express clearly what the quid pro quo relative, the terms and conditions are. And that usually then creates a conflict, a controversy, goes to court, and that's where the courts come in to play a role into trying to give an effect to the contract that you imposed upon yourself. Here's a re-expression of that doctrine, freedom of contract. It comes from a case called the Royal Winnipeg Ballet versus the Minister of National Revenue at the Federal Court of Appeal. Justice Evans goes on to state, he goes, freedom of contract is a fundamental principle of the common law of contract, with some specific limitations, i.e. if it's unconscionable terms and conditions. Parties may contract on whatever terms they think will best advance their interests. It also means that the courts must give effect to the terms on which the parties intended to contract. So I hope that helps you by looking at those few elements, those doctrines, what a contract is and what the role of a court is relative to that contract. We're going to look at another court case. This one's from the Supreme Court. It's MJB Enterprises Limited versus Defense Construction Limited. It's 1999. So a lot of these court cases are very current and, again, once again, re-express principles. The judge in this case, at paragraph 44, goes on to state, as this court stated in Cartwright and Crickmore Limited versus McInnes in 1931, which shows you the historical reality of your right to contract, there can be no recognized custom in opposition to an actual contract, and the special agreement of the parties must prevail. So again, once again, I hope that starts planting some seeds, connecting some synapses, that this right you have to contract is very powerful, and the courts are very aware of it, and they've been aware of it since the origin of Canada because it grew through the common law. So we're going to move on to what's called the fourfold test. There are 4 parts we're going to look at. Here's the general purpose, the evolution, the misperception, and the big question. So the general purpose of the fourfold test, it goes, in general, the purpose for the test is to determine whether a worker is an employee or self-employed. However, the predominant purpose for the test is to make a determination whether a worker is an employee in a pensionable employment for the purposes of Canada Pension Plan and insurable employment for the purposes of the Employment Insurance Plan. This test is used at many levels, a lot of provincial legislation, but primarily where it gets a lot of use is at the federal level relative to these 2 subject matters, pensionable employment and insurable employment. So we're going to look at the evolution of this fourfold test. For the most part, a lot of people consider the test to consist of 4 factors: the right of control, the ownership of tools and equipment, the chance of profit and risk of loss, and the 4th one, integration. The question is, though, is this an exhaustive list? And that's what we need to explore. Is this an exhaustive list, or is there other elements that need? And to do that, we need to look at the evolution of the fourfold test. This comes out of We Door Services Limited versus the Minister of National Revenue in 1986. It was a federal court decision. Justice McGugan states, he goes, "The traditional common law criteria of the employment relationship has been the control test as set down by Baron Bramwell in R versus Walker, 1858. So it shows you it's very historical. Canada became a country in 1867. So this principle existed before Canada itself existed as a country. He goes on, it goes, "It seems to me that the difference between the relations of master and servant and a principal agent is this. A principal has the right to direct what the agent has to do, but a master not only has that right, but also the right to say how it is to be done." He goes on in that case, he continues, he says, "Perhaps the earliest important attempt to deal with these problems was the development of the entrepreneurial test by William Douglas, Vicarious Liability and the Administration of Risk, 1928. So we're moving forward through history here, which posts 4 differentiating earmarks of the entrepreneur: control, ownership, losses, and profits. Notice what's missing there. Okay, so at that point there was 4. It was essentially this test which was applied by Lord Wright in Montreal versus Montreal Locomotive Works in 1947. So we see by 1947 they have this test that consists of these 4 parts. In earlier cases, a single test, such as the presence or absence of control, was often relied on to determine whether the case was one of master and servant, mostly in order to decide issues of tortious liability on part of the master or superior. In the more complex conditions of modern industry, more complicated tests have often to be applied. It has been suggested that a 4-fold test would, in some cases, be more appropriate, a complex involving control, ownership of tools, chance of profit, risk of loss. Control itself was not always conclusive. So what you're seeing here is, although it started with the control, the one question, who has control, that itself was not enough, and they had to move forward and look at putting other elements into it. So at this point, at least by 1947, they had 4, but there's still a part missing in there. Later on in that same court case, he goes on to say, the organization, which is known as the integration test, was approved by the Supreme Court of Canada in Cooperative Insurance Association versus Kearney in 1965. So again, as you see how it's evolving. Where Spence, for the court, quoted with approval the following passage from Fleming, The Law of Torts, from 1961 book. Under the pressure of novel situations, the courts have become increasingly aware of the strain on the traditional formulation, i.e. the control test. The most recent cases display a discernible tendency to replace it by something like an organization test. Was the alleged servant part of his employer's organization? Was his work subject to coordinational control as to where and when rather than to how? So again, you're seeing it's evolving. The courts are doing their best, in a sense, to try to figure out what is the best way of making this determination when there's an issue at hand. Here's CRA's perspective of this 4-fold test. This comes off of a PowerPoint course which is available online, and I'm assuming they've created it for their own staff. Saskatoon, June 2004, the headquarters by Vicki Adams and Lorraine Maison-Nouveau. They listed out here, the 4-in-1 test. This test consists of looking at 4 elements: the right of control, the ownership of tools and equipment, the chance of profit and risk of loss. See how they combine those 2, and integration. So it's still a 4-fold test. They just combined 2 and created a new category. But then what's interesting here is they go on to say, intent should only be used when other factors are inconclusive, which my understanding of what they're trying to portray there is, here we have 1, 2, 3, 4, we go through here, and if there's still a question, then we'll question the intent of the parties involved in the contract. So it's an important note that we have to consider here. CRA promotes the position that intent should only be used when other factors are inconclusive. Is this what the courts say as well, or is this merely an unfounded opinion? And that's what I hope, that question we're going to try to answer as we go through and explore their perspective on things. So here's the common misperception. It's important to understand that the so-called fourfold test is a misnomer, as the test is actually a holistic analysis of a non-exhaustive list of factors of the relationship between a payer and a worker. No single factor determines whether a worker is an employee or an independent contractor. All factors are relevant and must be considered as a whole. Now, I didn't just make that up for convenience. It's supported by the Supreme Court in Ontario Limited versus Sagas. This case is known as Sagas in 2001. The Supreme Court of Canada confirmed the use of this test in recent cases. Justice Major goes on and says, it bears repeating that the factors constitute a non-exhaustive list and there is no set formula as to their application. The relative weight of each will depend on the particular facts and the circumstances as the case. So that's completely different from this monodimensional approach we hear from the government. Here's these 4 points, and if after going through those, if it's in question, then we'll question your intent. Yet, when we look at that, that could actually result in a lot of unjust rulings if they're not applying the test right, if they're not taking all the parts into consideration. So it brings us to the big question. Who decides whether you have to take the test or not? Now, how many people, again, if you've experienced that, what is your perception of who decides? I can almost guess it's going to be they decide, right? Why? Because that's how we've been trained. Have we ever stopped to ask the question, who decides? Have we ever stopped to contemplate that maybe we get to decide, and maybe because we're unaware that we get to decide, they decide for us? So we're going to explore this question and look for this answer. Because when you flash back to your freedom of contract between you and another party and privity of contract, where does this outside influence get to come in and dictate what your intention of your contract was? So as we explore the answer to this, here's one possible answer is the government. With a position that legislation is written to be broadly interpreted, then without any prior request made by either a payer or a worker, an authorized officer of the Canada Revenue Agency has the legislative authority to make a ruling on an employment relationship. That I can almost guarantee if you walk out and talk to the average business person, the average employee, that will be one possible answer that they'll tend to lean to, correct? But here's another possible answer, and it is you. It goes on, it goes, when consideration is given to the principles of interpretation as expressed by the Supreme Court in R versus McIntosh 1995 and applied to the relevant legislation, such as the Canada Pension Plan, then, in respect of long-standing doctrines of contract law, it is the right of the payer and a worker to decide the intended nature of their employment relationship. However, if the payer and worker are unaware of this right, or they can't decide on the nature of their relationship, either party can make a request to an authorized officer who shall make the ruling within a reasonable time after receiving the request. And if one party disagrees with the ruling, that party has the right to file an appeal to an appeals officer who can make a decision on the appeal on his own initiative. That second possible answer is what our research has concluded, based on, not an unfounded opinion, based on looking at legislation. So that's what we're going to do. We're going to start looking at some relevant legislation. To answer that question, really, we just need to look at the Canada Pension Plan Act. Before we get into the act itself, let's flash back and remind ourselves now, what is the meaning of words that we're going to be looking at? And again, here's the quote from Lord Green, how he looks at it. It goes, in this statute, in this context, relating to this subject matter, what is the true meaning of the word? So that's the question, the parameters in which we're going to look within the act. And again, remind ourselves, legislation is deemed to be well drafted and to express completely what the legislators wanted to say. And I think it's important to stop, flash back, and remind ourselves of these principles, because when we get in there, you'd be amazed how much our opinions and emotions of what we think it should say or what we want it to say or what someone else told it said, how all those intangible influences start playing with our minds. So we need to really come to that solid thing. The courts say they're well drafted, period. And that allows us to remove our emotions, our opinions, and accept reality for what it is. So what we're going to look at is, what is Parliament's intent for the true meanings of these 4 words? One word we're going to look at is the word request. What is it, and who can make one? Second word we're going to look at is the word ruling. What is it, and who can make one? The third one is appeal. What is it, and who can file one? And the fourth word we're going to look at is decision. What is it, and who can make one? That is going to be the scope of our analysis relative to that. And to do that, we need to respect these principles of interpretation. we need to start off by reading some sections of the Act that contain one or all of these words to try to get a feel for what Parliament intended those words to mean relative to the context of the Act as a whole. So we're going to start here with section 21.1. Okay, it's the collections of contributions, employees and employers, the amount to be deducted and remitted by employer. Okay, so let's keep an eye open for any one of those four words so we can see how they fit into the general context of the Act as a whole. Every employer paying remuneration to an employee employed by the employer at any time in pensionable employment shall deduct from that remuneration as or on account of the employee's contribution for the year in which the remuneration for the pensionable employment is paid to the employee, such as a determination in accordance with the prescribed rules, and shall remit that amount, together with such amount as is prescribed with respect to the contribution required to be made by the employer under this Act to the Receiver General at such time as is prescribed. So we don't see any of the four words in there, but what you see in here is the object of the Act. What is the Act trying to achieve? What is the scheme of the Act? How does the process work? Basically, and you're all familiar with it, right? If you're an employee, when you get your paycheck, what do you see? An amount deducted for CPP. If you're an employer, what do you see? You deduct the amount off their paycheck for CPP, plus you add in the amount, the employer's portion of CPP, and you remit that to the government, hopefully on time. Correct? Okay, so there's the context, the scope, the object of the Act. So let's move on to 21.2, the liability for failure to deduct and remit. Subject to subsection 3, every employer who fails to deduct and remit an amount from the remuneration of an employee as and when required under subsection 1, which is what we just looked at, is liable to pay Her Majesty the whole amount that should have been deducted and remitted from the time it should have been deducted. So if you have an employee, what are you supposed to do? You're supposed to deduct, and if you don't deduct, what happens? You're liable for the amount that you should have deducted. Okay? So we're getting a bigger picture of what the Act is trying to achieve here. Here we go on to 21.3. Subsequent decision. It's a limit on that liability. See how 2 made it a broad conceptual idea of liability, but 3 says, hey, relative to a subsequent decision, here's a limit on liability. An employer is not liable for any amount that the employer fails to deduct as required by this Act from the remuneration of an employee, or for any interest or penalty for that failure if the employer is informed in writing in a ruling, so we're seeing that word now, under section 26.1, that the employer is not required to make the deduction. So we're seeing the first use of the word ruling. Basically, if you've been given a ruling by a CRA agent, an authorized officer, that you weren't required to deduct it, you're not liable. Okay? This is 21.3c. It goes, an employer is not liable if it is subsequently decided under subsection 27.23, the appeal to the minister, is what that is, or section 28, it's an appeal to the tax court, that the deduction should have been made. So what aren't you liable for? The whole thing, or maybe the interest and the penalties? And that gets clear when we look at the next section, 21 bracket 3.1. Once the decision under subsection 27.2 bracket 3, the appeal to the minister, or section 28, the appeal to the tax court, is communicated to the employer is liable without interest or penalties under this Act to pay the contribution required to be paid by the employer with respect to the employee. So if there is that controversy and it goes all the way through those steps, the employer is still liable for the initial premiums, but not liable for the penalties and the interest. Okay, so what did we see here though is the use of the word decision. And what have we seen? The context in which decision is, what is it at this point appear to be in relation to? A decision relative to the appeal to the minister or the appeal to the tax court. So this brings us to this question, who can request a ruling? You'll find this in section 26.1 bracket 1. The Minister of Social Development, an employer, an employee, or a person claiming to be an employer or an employee may request an officer of the Canada Revenue Agency authorized by the Minister of National Revenue to make a ruling on the following questions. There's a whole list of questions, but the one that we're primarily being looking at is whether employment is pensionable. And if it's pensionable, then you're an employee and the employer is required to deduct at source. So what is this section silent of? Nowhere in there does it say an employer, an employee, and an agent of the Canada Revenue Agency. No, it is very restrictive to the Minister of Social Development, an employer, an employee, or person claiming to be. They may request an officer of the Canada Revenue Agency authorized by the Minister of National Revenue to make a ruling on your request. Okay, so again, this comes back to that point of let's not add words to statutes, let's just read it for what it is, because we're trying to isolate what did Parliament intend by these 4 words we're looking at. Here's more support for that on who can request a ruling. This is right off their website. If you type in this bottom section, you'll get taken right to this page about requesting a ruling. It goes, an employer, an employee, or a person claiming to be an employer or an employee can request a ruling. If an employer is not sure whether CPP contributions and EI premiums should be deducted from a worker's pay, the employer can request a ruling from us. The same is true for a worker who wants to know whether CPP contributions and EI premiums should be deducted from his or her pay. So it's really what it is. It's a service they're providing. But if you noticed, look in here as we read through this whole thing. Notice what it doesn't say relative to who can make a request. Okay, the second paragraph goes, an employer or worker can request a ruling by sending a letter or completed Form CPT-1 to the nearest tax service office. The employer can also request a ruling online by accessing the business number. The Canada Employment Insurance Commission, the CEIC, an entity under the umbrella of Human Resources and Social Development, can also request a ruling from us. So they've gone to the extent of laying out truly who can request a ruling. You'd think if they had this authority, they would make sure, put in a line there, and so can we. Okay? Generally, the CEIC will request a ruling when it's not sure whether the worker was working in insurable employment or had insurable earnings or insurable hours. So this is a request that results from an inquiry from a worker themselves. So here's the form, CPT-1, and again, as you read on there, it's who is completing the application, the worker, the payee, or a representative. Nowhere on there do you say, is there even a space for an agent of the CRA to request a ruling on your behalf? Okay? So this brings us to the ruling and appeal process. This again comes off the same page of the website. It's the ruling process. Once a ruling has been requested, now notice the language. Once a ruling has been requested, an authorized CRA officer will contact the worker and employer to discuss the working arrangement that was or is in place. Sometimes the officer has to ask the employer for more information, such as payroll records, copy of written contracts, if any, or other related documents. On receipt of the necessary information, the officer will decide whether or not the worker was or is an employee working in pensionable and insurable employment for the purpose of Canada Pension Plan and the Insurance Act, or both. Once a ruling has been made, the officer sends a letter to the worker and the employer informing them of the decision. And what happens next? If one of the parties is not happy with the decision, they can appeal the ruling. Appealing a ruling. Every ruling can be appealed, and the procedure for doing so is explained in the letter sent to the worker or the employer. More information about appealing a ruling can be found in our pamphlet called Your Appeal Rights Employment Insurance Camp. So it's again, as you see, just on their own internal documents or their own publicly released information bulletins, they lay out a very nice process. You make a request, there's very limited, they make the ruling, and if one of the parties to the ruling disagrees, they can make an appeal. So let's see if we can support this in the legislation, if we can find a parallel to this. This brings us to 26.13. It's under the heading ruling. The authorized officer shall make the ruling within a reasonable time after receiving the request. So here we're starting to see the use of those 4 words. We see who makes the ruling and after receiving a request. And again, the appeals of the ruling, section 27, an appeal to the minister, which is the Minister of National Revenue, from a ruling may be made by the Minister of Social Development at any time and by any other person concerned within 90 days after the person is notified of the ruling. So what you have here is you have a limitation on yourself, if you're the employer or the employee, after you made the request, to appeal it, but the Minister of Social Development really has no restricted time frame. But we're seeing in here again the use of the word ruling, the use of the word request, and the use of the word appeal now. So here's the notification of appeal, section 27.21. Where an appeal is made to the minister, i.e. the Minister of National Revenue, under section 27 or 27.1, the minister shall notify any person who may be affected by the appeal that the minister intends to decide the appeal, including the Minister of Social Development, in the case of an appeal of a ruling. Okay, so there's what they have to do when appeal is filed. And they have to give the person an opportunity to provide information to make representation to protect the person's interest as the circumstances require. So now what we're seeing here is a very good use of the combination of those words. We have the minister intends to decide the appeal, and we have in case of an appeal of a ruling. So you're starting to see where these words fall into place. We got a section here, move on, that's with the heading decision. Section 27.23 says, the minister shall decide the appeal within a reasonable time after receiving it, and shall notify the affected person of the decision in any manner that the minister considers adequate. So, when we look at this word decision alone, what would your best guess as to Parliament's intent for the use of the word decision? What is decision relative to, is probably a better way of looking at it. It says it right here. The decision is relative to the appeal. The minister shall decide the appeal, and it's his decision out of that. But it goes on to say here, the minister's authority is not restricted. Section 27.3, nothing in sections 26.1 to 27.2 restricts the authority of the minister to make a decision. To make a decision on what now is the question? To make a decision on the appeal. Have we seen the Minister of National Revenue be given any legislative authority to make a decision on anything other than an appeal? If we go to what the words, if we take respect the principle of interpretation, that these things are well drafted, we see this very clear connection between the word decision and its connection to the word appeal. Okay? So let's recap our analysis. The word request, it's by a worker or payer for a ruling. Is that not what we read? We're comfortable with that. A ruling, it's by an authorized officer from a request. Notice how the ruling had to follow the request. So without a request, the question asks, does the authorized officer have the right to walk around this country, just make rulings without request? You would think that if Parliament intended to give them such authority, they would have done so in clear language, as they laid out clear language for everything else. Again, word 3, appeal, it's by a worker or a payer on a ruling. Okay, and decision, a decision is what? It's on the appeal that was made by who? By the minister. Okay, so what we've got to ask ourselves is, do the pieces fit? When we looked at these sections and addressed these 4 words and read them within the context of the Act and the object and the object of the Act, what it was trying to achieve, was there a harmonious understanding of those words? Did it create any confusion in your head, or was it relatively clear? Okay, so we can look, do the pieces fit? To answer that question, it's probably best to start with another question. Is our analysis in respect to the Supreme Court of Canada? So when these 4 words are read in the grammatical and ordinary sense, in light of the intention of Parliament, embodied in the Act as a whole, the object of the Act and the scheme of the Act, are they clear and unambiguous and in harmony with that intention, object and scheme, and with the general body of law? And that is that question. That was the bar that the Supreme Court said, if we're going to read a statute, we need to read it from this perspective and ask these questions of ourselves. So if you answered yes, then as the Supreme Court said, that is the end. So I hope with those 4 words, you have now really have a clear understanding of how this process works. There's a request. It comes from an employer-employee or via an employee through the Minister of Social Development to an authorized officer who will make a ruling, and if anybody disagrees, they can file an appeal to who? To the Minister of National Revenue, who will do what with the appeal? Make a decision on the appeal. So again, I may be, how we say, overemphasizing the simplicity of it, but there's a point to that which we'll see later. So what we needed to achieve, come to achieve, is the understanding of it's very harmoniously. There's really no question as to Parliament's intent on that, because it was so clearly expressed by Parliament in the legislature. Which brings us now to this lower court's questionable ruling, which is again why I overemphasized the harmonious elements of what we just discussed. This comes out of Drossovich versus the Minister of National Revenue in 2008, Tax Court of Canada. Okay, it's actually a very recent case, and it's actually a very unique case on many fronts. It was from a person who became aware that CRA may not have had the legislative authority to walk around this country and make rulings without requests. And so that's the perspective when it went to court, is to say, well, hold it. Even though they made a ruling, is the ruling of any force or effect, because they had no legislative authority to make that ruling? So here is the appellant's position in the tax court. It starts at page 10 of the transcripts. It goes, all right, well, I just want to make, opening statement here, and I feel that before we can move forward in this matter, that the issue that needs to be decided here is whether or not the Canada Revenue Agency or any of its departments or the Minister of National Revenue have, in addition to the legislative authority to make a ruling or a decision, in other words, the legislative authority to make a request for a ruling that would be needed to be ruled or decided upon, as at no time have any of the appellants ever submitted a written request for a ruling to the Canada Revenue Agency. So that was the fundamental essence of her position. Now, many things happened in that. Was that even the appropriate question to take to the Tax Court of Canada? Should that question have gone for a judicial review? I think even all parties, I think Crown felt, it was a question for judicial review, and now that they're in tax court. But I guess the judge said, well, no, we can deal with that here. So there's a lot of ambiguity on that, which will make itself clear in the future here. So here's the CRA's position. It's on page 51 of the transcripts. It's the respondent's position, the CRA, that Section 94 of the EI Act and Section 27.3 of the CPP, the Canada Pension Plan, which we just looked at, gives the minister the authority to make such a ruling. Okay? Now those provisions, Section 94 of the EI Act and Section 27.3 of the Canada Pension Plan, are broadly written provisions that say the administrative authority is not restrictive by previous sections. So I don't know if you understand what you're trying to say there. They're saying because of this Section 27.3, any restriction on the minister to do something has been released because Parliament's use of the word decision is to decide whatever he wants on any issue. So we're going to see how that bounced out and see where the ruling came through. This is the ruling from the tax court, and this is the judge speaking. It goes, Ms. Droshevich argues that since persons authorized by those sections to request a ruling do not include Canada Customs and Revenue Agency's Revenue Collections Division, the person who actually made the request, and I believe in this case they actually have a letter from CRA stating we made the request, raising the question, where'd you get the authority? Okay, the proceedings were begun without authority and the rulings ought to be vacated for that reason alone. Now that's a very rational, logical argument. If you had no authority to make a ruling without a request, and nobody made a request, what force should your ruling have? So it's a good argument there. Okay, now this is what the judge says about that. This argument is without merit. That's a stumbling block for the vast majority of Canadians. A judge spoke, it must be right. Well, think about it. Here we have lower courts all across this country. Then we have appeal courts. Then we have the Supreme Courts. Provincial Supreme Courts, federal Supreme Courts. Okay, we have the highest court in the land, the Supreme Court of Canada. If all judges, that everything came out of their mouth was the absolute truth in law, what would be the need for appeal courts, Supreme Courts, et cetera, et cetera? So we got to watch ourselves that we do not adopt words blindly, like this argument is without merit, that must be the end of it. It's at the lowest court in this land, a low-level court in this land. So he goes on to explain that. He goes, the Minister of National Revenue is empowered by Section 94 of the Act and Section 27.3 of the Plan to make a decision on his own initiative. He's very correct there. Is that not what we read in that Section 27.3? The minister has the authority to make a decision on his own initiative. So there's no dispute there. He goes on to read them. He goes, they read as follows. And we're going to zoom in and focus on 27.3 because they're virtually identical. It goes, nothing in Section 26.1 to 27.2 restricts the authority of the minister to make a decision under this part on the minister's own initiative or to make an assessment after the date mentioned in subsection 26.1. So what they're relying on is that what they're saying is that this Parliament intended for this section to say that the minister or anybody delegated by the minister could make a decision on any broad range of ideas, make a decision to make a request, make a ruling, i.e. ruling meaning decision. So a whole bunch of convoluted things. He explains that clearer down here. He goes, the ruling officer is a person acting on the minister's delegated authority, and his ruling, in this case, are authorized by those sections. So the question is in this section that was relied upon by the judge, relied upon by the Crown, does it actually give the ruling officer, which there is no such thing, by the way, it's an authorized officer, the authority to make a ruling on his own initiative without a request? I think, again, when we go back and we respect the principles of interpretation, we see it right here. Section 26(1), the authorized officer shall make a ruling within a reasonable time after receiving the request. Okay? And the decision, the minister shall decide the appeal within a reasonable time after receiving it and shall notify the effect of the decision. And again, what was Parliament's intent for the use of the word decision? What is the word decision connected to? Is it connected to a ruling? No. You can see very clearly Parliament intended for decision to be relative to an appeal. How do you get to an appeal if at first you have no ruling and before that you have no request? So what they're trying to say is that the word decision is actually equivalent to the word ruling. Well, take a look. If that was the case, why would Parliament use ruling up in 26(1)? Why didn't they just use the word decision up in 26(1)? The unauthorized officer shall make the decision. Then it would create ambiguity, wouldn't it? Because now we wouldn't be sure as whether the decision was relative to the request or whether it was relative to the appeal. Okay? So before we move on, let's go back to section 27(3) of the ruling and look at another argument they'll try to bring forward. They say this section says nothing in section 26(1) to 27(2) restricts the authority to make a decision. What they're going to focus on is the words nothing in these two sections restricts the authority of the minister. Great. Who is the minister? The minister is the Minister of National Revenue. And it doesn't say in here, the Act was very clear, whenever it was referring specifically to the minister, it wasn't referring to the authorized officer of the minister. So there's one point there. But what it restricts the authority to do what? To make a decision. Well, again, I think we all saw very clearly Parliament intended decision to be strictly and solely connected to the word appeal. But nevertheless, let's give them the benefit of the doubt and look at these words, nothing in these sections. Because these sections did include the section of who gets to make the request and who gets to make the ruling. The reason Parliament had to use this nothing in sections here is not to override the idea of who requests and who makes a ruling. It's because 26(1)(4), it's subtitled Presumptions, created two legislative presumptions. It states, basically one part states that if contributions were deducted, it was deemed that they should have been deducted. And if premiums weren't deducted, it's deemed by legislation that they weren't supposed to be deducted. So here you have these two definitives. So if you went all the way through tax court and then judge, or through the appeal, and they made a decision that you should have deducted it, you can say, well, hold it. The legislation already deemed it that they didn't have to be deducted. So the reason they used nothing in these sections was to override or to mute those two statutory determinations, pre-existing statutory determinations. Because without muting them through these words, then the minister's decision would be useless. Okay? But that's an argument they'll go to, but it's really a red herring. It has no substance because when you focus back to the word decision, what is Parliament's intent for decision to be connected to? An appeal. Okay? So is it an obvious error in law? Again, when we look at what the Supreme Court has said, again, the highest court in the land, talks about this contextual approach. Okay, there is certainly support for a contextual approach to statutory interpretation. He goes, today there is only one principle or approach, namely words of an act are to be read in their entire context and in their grammatical and ordinary sense harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. The only way you can get decision to mean ruling is by ignoring all the rules and throwing in your opinion to preserve some concept of legislative authority that Parliament never intended to grant. Okay? So, is there an appeal pending? Oh yeah. Like I say, that was a brand new case. It was very unique from probably the only one I'm aware of where the person involved went and said, hold it. Before we decide whether they're employees or employers or not, let's go and see if you even had the authority to make the ruling without a request. And there's many elements to this case, and here's another thing. Normally when a case goes to tax court, it's the Tax Code of Canada Act, there is a legislative requirement, imperative actually, of how long it should take for a judgment to be rendered. 18.22 subsection 1 goes, the court shall, and that's a statutory imperative, other than exceptional circumstances, and exceptional circumstances is they're waiting for paperwork, and none of those elements existed in this case, shall render a judgment on an appeal referred to in section 18 not later than 90 days after the day on which the hearing is concluded. So not only is there the issue of, was there an error in law that needs to be appealed? Did the judge himself respect and honor take the contextual approach to come to his decision? There's one point of appeal, but here's another one which is even more interesting, is the proceeding concluded on August 20th, 07. The judgment due date, according to the legislation, was supposed to be out on November 20th, 07. The judgment release date was April 1st. Over 4.5 months past the legislative requirement of the release of the judgment. So that in and of itself raises a lot of peculiar questions, is what are they going to do? The last thing, it's hard to say who's doing what or what's doing what, but it makes you wonder why, despite the statutory imperative, it took 4.5 months after to release a 6-page ruling on what would be a very basic issue at law. Okay, so this one's definitely being appealed, and I think as you saw yourself, you go through those words, and to attach any other meaning to decision, i.e. Parliament intended to grant any agent of the CRA the authority to walk around and make a ruling on their own initiative, is not only ludicrous, there's just literally no way to support that without totally disrespecting every principle that this legal system is built upon. So this brings us to the common misperception. Despite the unsustainable common misperception that legislation is written to be broadly interpreted, one cannot, without disregarding well-founded principles of interpretation and long-standing doctrines of contract, reasonably conclude that Parliament granted legislative authority to authorized officers of the CRA to make rulings on an employment relationship without a request first being submitted by either a payer or a worker. So it brings us to a reasonable conclusion. Once again, when consideration is given to the principles of interpretation as expressed by the Supreme Court in R versus McIntosh 1995 and applied to relevant legislation such as the Canada Pension Plan, as well as with consideration of long-standing doctrines of contract law, it is reasonable to conclude that the payer and worker have the right to decide the nature of the relationship and to express such in clear and unequivocal terms in their employment contract. Again, I can't comprehend how someone could come to an alternative decision to that without totally being willfully blind to every legal principle this country was built upon. So here's the bottom line on a ruling. Remember, freedom and privity of contract. These are fundamental principles of contract law, rooted in our legal history long before Canada even existed. Okay, so remember, freedom and privity of contract. Don't ask and you won't receive. And in the event CRA asks you, just say no. It really might become that simple. Just say no. You don't have to be disrespectful. You say no, we do not, neither the payer nor the worker requests a ruling. We're very comfortable with our understanding of our employment relationship. If they give you a little bit of intimidation that they have some legislative authority to do so, then you ask them to show it to you. You just went through the whole scope of the CPP Act relative to who has legislative authority. Maybe we missed something. Well, if we missed something, have them show it to you. Because I believe me, if we missed something, the judge would have showed it to us within the ruling, and he wouldn't have simply relied on an ambiguous interpretation of a section that had absolutely nothing to do with requests or rulings and only had something to do with the decision on the appeal. So let's move on to relevant case law. Like I say, what there is here that we're discussing is really two issues. One issue is, which we just discussed, who has the authority to make a ruling and what are the conditions under it. Okay, and again, the conclusion was without a request, they have no authority to make a ruling. Okay? The other part we're looking at here, though, is relative to your right to contract and that fourfold test and how that is in relation to what the courts say relative to that. And to do that, then, we have to look at some case law to get a good understanding of it. What we have in the binder program itself is 6 case law. They're extremely important, each for their own different reasons. Okay, the first one that you'll find in there is called R versus McIntosh, 1995. It dealt with principles of interpretation. We touched on 1 or 2 principles here. If you read that, you will understand to a greater depth than we could ever explain here the power, the scope of principles of interpretation. Statutes, again, are not read like storybooks. So I encourage everyone to read that. The next one we're looking at, again, we used one quote out of it so far, is the Weed Door Services Limited versus Minister of National Revenue. It's a great case from the perspective it gives you a very good historical evolution of the fourfold test. And again, that was some of the excerpts we looked at. Another one is this Ontario Limited versus Sagas. It's from the Supreme Court. And what's good about that, it reiterates at the highest court in this land that there's no one conclusive test. It's a confirmation of that. But it's a case that primarily dealt with vicarious liability. That in of itself is a subject matter that is really interesting, because as an employee, the employer is actually liable for your actions. So this case dealt with, is the employer liable for the actions of someone who's self-employed? So it's a great concept in that. Again, number 4, Drocevich versus Minister of National Revenue, the lower court's questionable ruling. The whole transcript's in there, the judgment's in there, so you can read it in its entirety. And the one that we're going to spend a lot of time on is the Royal Winnipeg Ballet versus Minister of National Revenue. It's quite recent itself. It's 2006, and it's Federal Court of Appeal. To me, it's the best source for holistic support for your options. So we're going to spend a lot of time on that. Here's the case background. Despite the intention of both parties involved, an authorized officer of the CRA ruled that Royal Winnipeg Ballet dancers were employees and not self-employed. That's very important to understand. Both the company and the dancers had no issue whether they were employees or self-employed. They believed they were self-employed. So once the ruling came out, the Royal Winnipeg Ballet appealed the ruling to the Tax Court of Canada, which in turn upheld the authorized officer's ruling. Again, they exercised the right to an appeal, and the RWB then appealed the tax court's decision to the Federal Court of Appeal, which in a 2-to-1 decision overturned the tax court decision that they were employees in favor of the intention of the Royal Winnipeg Ballet and the dancers to be self-employed. So it's a very interesting case. It's when we understand this whole evolution of employment relationship has gone through many dynamic changes, this becomes a very educational court case to review. And so we're going to spend some time on that by starting to look at what happened, just some basic background. This is from Justice Evans. He was a dissenting judge. He was the one that ruled that they were employees, where 2 other ones ruled that they were self-employed. He goes on to state, the legal relationship between RWB and each dancer is determined and governed by the Canadian Ballet Agreement in force for that season. The Canadian Ballet Agreement is an umbrella agreement under the Canadian Actors Equity Association and the Royal Winnipeg Ballet. The RWB agrees to engage only persons who are members thereof. The record established, this was through the trial, that the understanding of the Canadian Actors Equity Association and the dancers and the RWB was that the dancers covered by the Canadian Ballet Agreement are independent contractors and not employees of Royal Winnipeg Ballet. So that was the understanding of all the parties involved here. So what happened? Why did this even go to court? One, because the guy made the ruling. Okay? But the contract was silent. He goes on to continue. He goes, however, despite their understanding, there was no contractual instrument that purported to characterize the dancers as either employees of RWB or as independent contractors. And that was very crucial. So what you had was they had the employment contract, which is extremely rare when you consider employment as a whole. Most people work under oral or verbal contracts, employment situations. So even though they had a written one, it was silent on their relationship. He goes on to finish off here. The Canadian Ballet Agreement sets minimum rates of remuneration, contributions to healthcare plan, and so forth. For all fiscal purposes, the dancers and RWB acted consistently with their understanding that the dancers are independent contractors. The dancers are registered for GST purposes and charge GST to RWB for their services. Furthermore, the RWB does not withhold tax from the remuneration paid to a dancer except at the dancer's request. So again, they had terms, a lot of terms in their agreement, but the one term they didn't have was a clear term on what the nature of the relationship truly was. So their contract was silent. So it comes back to ask and you shall receive. This comes further on. It's the following are the reasons for judgment rendered in English by Charlot, Justice Charlot, one of the consenting judges. The RWB asked the minister for a ruling on this point for the purpose of determining whether it had any legal obligation in relation to the dancers to pay contributions under the Canada Pension Plan or premiums under the Employment Insurance Act. Such obligations would exist only if the dancers were employees. So what we see is perfect, right? What we just discussed in the Canada Pension Plan. RWB went and asked for a ruling. Okay, then the ruling officer shall, within a reasonable time, render their ruling. And if a party doesn't agree with it, what do? They go in and file an appeal. If they don't agree with the tax court's decision, they can file to the Federal Court of Appeal, which they did. Goes on to paragraph 3, it goes, a delegate of the minister concluded that the dancers were employees of RWB. The RWB, Miss Birtwistle, Mr. Wright, and Miss Suster appealed separately to the Tax Court of Canada. Each of them commenced 2 appeals, etc., etc. So where did this third-party interference come in? Okay, Charlot continues on paragraph 63. It goes, what is unusual in this case is that there is no written agreement that purports to characterize the legal relationship between the dancers and RWB. But at the same time, there is no dispute between the parties as to whether they believe that relationship to be. The evidence is that RWB, the CAEA, and the dancers all believed that the dancers were self-employed, and they acted accordingly. The dispute as to the relationship between the dancers and the RWB arises because a third party, the minister, who has a legitimate interest in a correct determination of that legal relationship, wishes to assert that the evidence of the parties as to their common understanding should be disregarded. Now, does this not go back to where CRA's PowerPoint presentation that they put out there is intent is the last thing you consider if it's not conclusive? And that's still the position they're holding here. So that was their position here because it's not consistent with the objective facts. Which raises the question, what if their contract did have a clause within it that actually expressed what the nature of the relationship is? So it brings us here a verifiable common intention. Charlot, again, the consenting judge, in referencing Wolf versus Canada, a case she relied on, in paragraph 51 goes, Justice Taxpayer rendered separate reasons in which he analyzed the issue somewhat differently, but reached the same conclusion as Desjardins. He also suggested that it might not even have been necessary to recourse to Weebdor or Sagas. Now, Weebdor and Sagas are the 2 court cases that we were talking about, which actually laid out the parameters for the test. And he's saying here, they might not even have to even go to the test. Why? Because the nature of their contract was so clear. And he goes on to repeat within there, he goes, taxpayers may arrange their affairs in such lawful ways as they wish. What is that an expression of? The Westminster Principle. No one has suggested that Mr. Wolf or Canadair or Kirkmeyer are not what they say they are or have arranged their affairs in such a way as to deceive the taxing authorities or anybody else. They just exercise their right. Okay? When a contract is generally entered into as a contract for service, which means you're self-employed, and is performed as such, the common intention of the parties is clear, and that should be the end of the search. So we see what happened in Royal Winnipeg Ballet. They had a contract, but what it was, it did not contain an element, a term, discussing what the nature of the relationship is. But as we see here, as far back as 2002 in the Wolf case, they're saying when a contract is generally entered into as a contract for service, that is the end of the search. Okay? So in this other paragraph, it's literally history repeating itself. What there is there's this common element that has existed since as far back as I can research any case law, but when we get so blinded by the elements of this fourfold test, we forget to look at the fundamental underlying element within a contract. And so Charlot, referencing back to the Montreal Locomotive case, which is in 1947, it goes, it seems to me from Montreal Locomotive that in determining the legal nature of a contract, it is a search for the common intentions of the parties that is the object of the exercise. Not this external test that people say, well, here, it doesn't matter what you think, we'll just run you through this test. No, what is the duty of a court relative to a contract? To give the contract effect to the intentions of the parties. And so that's what she's repeating here. The same idea is expressed as follows in the reasons by Taxpayer in Wolf at paragraph 117. I say with great respect that the courts, in the propensity to create artificial legal categories, i.e. the test, have sometimes overlooked the very factor which is the essence of a contractual relationship, the intentions of the parties. So again, this flashes back. CRA's promotion that intention is a last resort element to consider if you fail the test is ludicrous if you were to check what any of the courts have said, not only from 2006, but as far back in history. Because to do otherwise, you would literally destroy the fundamental principle of common law, of contract law. The court's role is to give effect to the intentions of the parties, and as far back as Montreal Locomotive, that was the issue. That was the search. They use the test to facilitate that search if the contract is silent. So let's look at some potential cons of asking for a ruling. Okay? Again, this is back to Evans, the dissenting judge in that. The determination of the status of the dancers had important implications both for the RWB and the dancers. The tax court's findings meant that the RWB would be obliged to pay employment insurance premiums and make contributions to the CPP. From the point of view of the dancers, it meant that their work as dancers for the RWB was insurable employment under the EI Act, and that they were not entitled to tax relief for certain expenses borne by the dancers. The issue was whether the tax court was correct in his findings for the purpose of EI and CPP that the dancers in questions were employees of RWB. He held that the appeal should be allowed, which means RWB would lose and the tax court decision would stand. Okay? But he was the dissenting one. The majority of the judges found in the alternative. So here's potential pros for not asking. And this is from Charlot, paragraph 29. Generally, a self-employed person may claim tax relief for all expenses reasonably incurred to earn his or her income from self-employment. By contrast, the tax relief available to an employee is restricted to a permitted list of items, most of which would not be applicable to a dancer who is an employee. This differential treatment assumes that essential employment expenses generally are borne by the employer. It is generally recognized that in particular cases, that assumption may not be valid. So what we have really is this whole idealistic scenario of employment-employer relationship. The employer is going to do this, the employee is going to do that. That may have existed in the early days, but we're in a lot different times now. And we're going to look at that, the evolution of this, whereas the judge herself said, the assumption may not be valid. A lot of things have changed. And I think they were recognizing that as this case gone. So let's recap your options. We have a common law right to contract, and the essence of contractual relationship is the intention of the parties. Okay, so when we look at Royal Winnipeg Ballet, what was missing? Their contract was silent. They had no, there was no dispute, but because they made a request, they got a ruling, and they invited that third party into their contract to resolve it. And that's what really boiled that. So it really boils back. What if you never make a request? It's a privity of contract. Why bring a third party in? Why not spend the time up front, actually, to negotiate and truly establish what the terms and conditions of your relationship are? Which in turn means no dispute, no request, no ruling, and no appeals. So the Royal Winnipeg Ballet could have saved a lot of time and effort and money running to a third party to resolve a dispute that really there never existed had they not have invited a third party in to create one. Okay, and like I said, I can almost guarantee that they never willfully sought out to request a ruling. They happened maybe upon a payroll audit, and the officer said, wow, gee, I think these are employees. And they said, well, no, they're self-employed. Well, here, fill out these tests. Just the action of filling out those tests could be seen as making a request. So when I say just say no, don't succumb without the legislative authority. We have rights as Canadians that these agencies are not above the law. We live in a country that's governed by the rule of law. We're all subject to the law. So no agency member, department, or agent of an agency has the authority to walk around and do things without legislative authority. We have a right to ask, where's your legislative authority to do that? So it's a very simple element that by asking the right question, it may save a lot of hassle and a lot of time. So let's move on to exercising your options. Now, when we look at what the case law says, that it's when the intentions of the party is clear, that's the end of the search. They don't even have to resort to the test. Okay? To really understand then what it is you really have to put in some education. To really study, and that's why the binder itself gives you each of these case laws so you can spend the time to truly study that and become comfortable within yourself. Now, how you say, we've also been trained, in one essence, is to look outside ourselves for answers. And what you're going to get is, because of where we're at in our social development, is you're going to get answers from people who also have never spent the time to read case law. They're literally are going to reiterate what somebody else told them. Say, for example, you have an accountant who has a couple clients who've been subjected to payroll audits and had self-employed who were converted back to employees and was dinged with thousands and thousands of dollars. What do you think his perception of who has the authority? He probably himself has never read the law. He's just going to give you a response relative to his experience. So that's why we put the case law in there, so you can actually read it and study it and establish it yourself. So as you're exercising your options, you got two choices. You can walk alone, which is really our hope and goal was that the course is in-depth enough that if you spend the time, you can build the confidence to do that. Okay? Or you have this other option, as we expressed in the You Have Option video. You can enter into a private agreement with a private tutor. Private tutor is one of our associates with Paradigm who are very well versed in the subject matter that we're dealing with here today, because this subject matter is just a minuscule element of this totality that we actually research. Okay, so if you want assistance with how to say increase your learning curve and verify, have someone to discuss what your understandings are and really get a good solid, there's that option. But as you're exercising, remember you have two choices. You can walk alone or you can engage a private tutor. So what we're going to do here is take a quick tour through history to give you a broader understanding of this evolution of employment relationships and to show you that what existed as common knowledge 10 years ago, 20 years ago, has drastically changed, not only from society's perspective, but even from the court's perspective. Here's the early years of natural commerce. In the early years of natural commerce, approximately 80% of the population was self-employed. Very few even contemplated the idea of a cradle-to-grave job. I mean, even today, that's becoming a concept that is long gone. This form of natural commerce had not only functioned free of government intervention for centuries, it came with a built-in mechanism of natural apprenticeship, or what we now refer as on-the-job training. It was this built-in byproduct of natural commerce that provided the necessary knowledge and skills for each generation of the remaining 20% to later pursue their own enterprise and enjoy the fruits of their labor. So very few people were actually employed for a long term. It was more of a stepping stone for them to develop the skills to step out on their own. What changed was, then came the Industrial Revolution. This new revolution reversed the early reality. The 80% now became employees working for the remaining 20% who own the few large corporations that were developing. See, that was that point in our history where there was a shift. It went from a world of self-employed, and that's why, as I say, as we track it through history, you'll see it was from the Industrial Revolution and on that we started needing to develop this test. This test that they talk about did not always exist. Okay? Then came the 80s. That was the start of a paradigm shift. As technology was advancing in leaps and bounds, and with respective cycles of booms and busts happening with greater frequencies, business was forced to adjust to a new type of economic reality. They found themselves carrying too many high-cost employees, which due to statutory employment laws created a financial burden that couldn't be supported when the economy slowed down. During the slow times, many businesses began terminating a substantial percentage of their workforce en masse under the politically correct term of downsizing. How many people here have been subject to this concept of downsizing? And if you haven't, just ask around. It was very prevalent in the 80s and 90s as the whole dynamics of industry and business were changing. Okay, so what it was the breaking down of this old way, that cradle-to-grave job. It no longer existed, and it caused a whole bunch of different elements to start developing. Brings us to the evolution of a paradigm shift. As better times returned, however, business was more cautious and didn't respond to the economic recovery by merely hiring more employees. Instead, we saw the start of a paradigm shift, a fundamental change in a way of thinking. As this shift caught on, the term used by business for this new way of hiring was called outsourcing, or contract employees, or, as in the labor relations book, dependent contractors. As technology improved, many companies found they were now able to contract out various divisions of their business, such as product installation, warranty programs, and even payroll administration, to name a few. This shift made the self-employed structure the fastest growing method for independent contracting. And I don't know where you're all at with that, but how many here have had the ideas, hey, I could do this in an independent capacity, not only for one company, but for many companies. Or even, I could do it very good for one company. So again, these aren't new ideas. What we're experiencing, what we're living in now is actually the latter part of a shift that started 20 years ago, almost 30 years ago. So the paradigm shift continues. This is right back out of the Royal Winnipeg Ballet, 2006. It's very interesting because, again, this comes from Evans, the dissenting judge. Even though he was dissenting, what he is expressing is the reality that we're all facing in society. This is out of paragraph 113. It goes, it is also appropriate to question the utility of a test devised before both the rapid growth of outsourcing and privatization of work had occurred and the effects of the globalization of the economy had become so apparent. The changing nature of the workplace and the increasing complexity and diversity of relationships under which labor is supplied are adapt to reduce further whatever value the weed door test may once have had to determine who is an employee for EI and CP purposes, and thus entitled to benefits that these statutory schemes provide. So here we have even the dissenting judge acknowledging the shift that is happening in the economy. And they're becoming very, in his own words, what value does this test have anymore, especially when we understand our fundamental, the principle of the freedom to contract, okay? And we become aware of that more. So shifting, step by step by step. Step one, educate yourself. Make an informed decision. Now, I may be oversensitive to this idea of educating yourself, but I've seen a lot of people get hurt by doing things without really understanding their right to do it, the options available, and primarily how to defend their decision in the first place. How many people do you know that have made the decision to work self-employed only to have that whole relationship collapse because they did not know to ask an agent, where's your authority to make a ruling without a request? So I'm very, Paradigm Education Group grew from that importance of education. So I hope I don't overemphasize it, but I look at education as in one way. It doesn't hurt. Yes, it may hurt to study, but once you know it, you only have to learn it once, and once you know it, it empowers you for generations to come. So I definitely put a lot of emphasis in that, and I suggest you do it so you can make an informed decision. When you realize that you have free will, your decisions are the result of your own choices. This is the same word, but nevertheless, your life is the result of the decisions you make. If you're going to make decisions, isn't it not prudent to actually be educated about the decisions you make? Okay? So again, I really emphasize on that one. Step two, the transition phase. Now this is a whole phase. If you're an employee and you're looking at exercising this option, there's going to be some steps that you're going to need to consider. One, you're going to need to negotiate a contract for service with the payer. Right now, you basically probably have an unwritten employment agreement. It was easy, wasn't it? You showed up, they told you to show up Monday morning, and boom, you had a job. Okay, as we saw in the Royal Winnipeg Ballet case, even with the contract, had it contained a few more terms or clauses, it in of itself would have saved everybody a lot of time, effort, and money. Because all they did was effectively jump through the tax court, jump through the appeal court, only to get back to where? Their intention in the first place. Okay, so you need to negotiate the terms of a contract. You need to terminate the contract of service that you're currently under. So there is an element in there. It doesn't just happen. And you need to enter into a contract for service. And one thing we'll have in here, we'll discuss later, is this: you may want to provide an optional affidavit of intention or get one. Now this whole area may be a brand new concept. And so it's a great area where you may want to consider engaging a private tutor. Because they're very, again, this element of what we're teaching here is just one element of the whole scope the associates are educated under. And to have someone to sit and discuss what are good terms within an agreement. So there's one area that you may want to look at engaging a private tutor for that. Step three is the record keeping. Now, if you're an employee, you probably keep some records. Maybe you keep your payroll stubs, maybe you keep your hours. But if you cross this line to be self-employed, you're entering into a whole new world. And you're going to have to look at developing skills to this on invoicing, some receipt management, and consider the new tax filing requirements. They're not that much more complex from just being an employee, but there are additional. We're going to look at some of these things. So first thing he says, contemplate the terms of a contract. Even in the case law that's provided within the binder, you'll get a lot of good ideas of the scope and range that terms and conditions. You understand, it's your right to contract, and when you sit down with a party, as long as it's not unconscionable to a reasonable person, whatever term and condition you guys can think of is, and both parties agree to it, it's available to you. So here we have Charlot, once again referencing Wolf versus Canada in paragraph 47. She goes, the contract established an hourly rate of remuneration. Okay, there's a good idea. The provided extra remuneration for overtime. See, even if you're not an employee, you can still negotiate overtime, vacations, and statutory holidays. So a lot of these things that you say you think you get because you're an employee, they are still available under a self-employed relationship if they're something that you want to consider and you negotiate within the terms. It also stipulated a per diem allowance payable in certain circumstances and a completion bonus if the contract was completed to Canadair's satisfaction. Canadair was also obligated to pay all travel costs incurred by Mr. Wolf in the performance of the contract. So again, I hope this sort of gives you an idea that you may want to spend some time contemplating the terms of the contract. Now, a great source to draw from is either case law that we have here or go online to the Employment Standard Act. The Provincial Employment Standard Act, what they are is a default employment contract. Now, you may not agree with everything that's in them, but that becomes your choice. There may be things that you like, and the wording's there. And so you can draw from that. Or, like you say, there's a lot of sources to contemplate terms of a contract. So it's a step that you may want to take if you're considering that. Contemplate benefits and burdens. Now, this is really funny because what really is a benefit and what really is a burden? Here's how I look at it. A benefit is really nothing more than compensation for services in a different form. So here's the benefits that an employee typically gets: CPP, EI, WCP. Each of these are available through private insurers, or some of them you can actually access even as a self-employed person. We'll go through the ones that you can do that. Extended medical and dental. Who's to say that you cannot negotiate that as part of your term and clause? We saw that in RWB. And so let's look at burdens. A burden is really nothing more than self-imposed obligation resulting from a choice. Like, say, GST, unless you're a small supplier. And the paperwork and the red tape. And as a decision, as you're weighing this, we discussed in the You Have Options video that you want to consider the pros and cons. Because it's not, like I say, the grass may be greener on the other side, but somebody's over there taking care of it. Okay? So, really, the way I look at it, benefits and burdens are a matter of perspective. And so you're going to have to spend some time contemplating that. Now, here's an interesting article out of the province. It's back from February 1994. It's their perspective on burdens. Is it a healthy perspective or what? It's titled, Too Many Rich Pay Too Little Tax. It's from an MP who was complaining. 20 Canadian millionaires paid less than $100 each in income tax in 1991, says a Liberal MP, calling for an end to tax loopholes to the rich. George Baker of Newfoundland said senior officials in the finance department had confirmed that 190 Canadians who earn more than $250,000 a year filed non-taxable returns for 1991. And that's the inequity between being an employee and being self-employed. As an employee, like you say, there's a very nominal list that you can deduct. But when you exercise your option to be self-employed, it opens that whole door. These guys believe it's a healthy perspective of it. The taxation statistics for 1992 or 93 haven't been compiled and released by Statistics Canada. Of the 190 people, Baker said officials told him 25% reported incomes of more than $1 million. Baker said 20 millionaires each paid less than $100 a year in federal and provincial income tax for 3 years in a row. Baker said officials also said live millionaires received social assistance checks that are designed for low-income Canadians. So that's why, again, it's like, who's to say what's right or wrong? Ask yourself, did you write the legislation? No. They wrote the legislation. If you act and structure your affairs within the scope of that legislation, is there really any moral issue? So, I mean, morally, we look, oh, these guys are making millions and then they're taking advantage of the social programs. They themselves never wrote the legislation either. So again, it becomes really, in one essence, a moral issue that you're going to have to decide yourself. It's a perspective that you're going to have to decide. So in this idea of benefits and burdens, I don't think anybody can make those decisions. What is a benefit? What is a burden? Because it really comes down to your choice. So contemplate those, educate yourself on the realities of them, and it'll allow you to make a decision a lot better. So we're going to look at a couple of these benefits that are basically mandatory if you're an employee, and look at are they still available and to what extent if you're self-employed. First one we want to look at is employment insurance. Types of insurable employment. This is section 5, subsection 1. Subject to subsection 2, insurable employment is employment included by regulations made under subsection 4 or 5. So there's a whole list actually of what falls under insurable employment, but we're looking at this one because it's relative to the distinction between a contract for service and a contract of service for self-employed. So section 5, subsection 4. The commissioner may, with the approval of the governing council, make regulations for including in insurable employment, employment that is not employment under a contract of service, which is what? Employment under a contract for service, self-employed, if it appears to the commissioner that the terms and conditions of service of and the nature of the work performed by persons employed in that employment are similar to the terms and conditions of service of and the nature of the work performed by persons employed under a contract of service. So really what that's telling you is you could be actually working as self-employed, literally side by side with someone who chose the option to work as an employee, and really because there's no distinction, if EI is a benefit that you dearly want, there's provisions to allow for that, to allow two people under the different types of contracts doing effectively the same thing to still have access to this type of benefit program. Personally, I'd highly suggest you really study the qualification elements of the Employment Insurance Act before you jump and think it's something you want without really truly understanding what it actually takes to qualify for it. The other one is workers' compensation. Now this section here is out of the BC Workers' Compensation Act, but generally all across this country, provincial WCB Acts, Workers' Compensation Acts are relatively the same. They use a little bit of different terms, but the point that we're going to be looking at here is, can someone who's self-employed have access to the WCB? So this is section 1 in this act. Here's the definition of a worker. A worker includes a person who has entered into or works under a contract of service. There you go, your employee, etc., etc. F goes an independent operator, someone who's self-employed, who is admitted by the board under section 2, bracket 2. So we go to section 2, bracket 2, it's the application. The board may direct that this part applies on the terms specified in the board's direction to an independent operator who is neither an employer nor a worker, which is an employee, as though the independent operator was a worker. So even if you're self-employed, you can still have access to WCB by making an application, and they will accept you for the most part as an independent operator and treat you as if you are an employee even though you're not an employee. So this benefit's still available if it's something you desire. This brings us to Part 9 of the Excise Tax Act, the goods and service tax. Okay? As self-employed, this may be something depending on the amounts you receive here, this may be something that you need to consider. Is it a burden or is it a benefit? It really depends. What it effectively, if you earn over $30,000, you're going to be required by the Act to register for GST. It comes out of Section 240, bracket 1. Every person who makes a taxable supply in Canada in the course of a commercial activity engaged in by the person in Canada is required to be registered for the purposes of this part, except where the person is a small supplier. A small supplier is defined in Section 123(1). A small supplier at any time means a person who is at that time a small supplier under Section 148 or 148(1). In short, the binder itself actually contains those sections, so you can look at the whole totality and scope of it. But in short, the total of all amounts, each of which is the value of the consideration, does not exceed the total of $30,000. So if your annual earnings are less than $30,000 relative to your self-employed relationship, you're not required by the GST Act to register because you're deemed to be a small supplier. If it's over that, then you're required to get it. And what comes with that is you need to keep, it's more paperwork. You need to keep more receipts. But in exchange, you are allowed now to file for GST tax credit inputs. So, you know, how it all washes out, whether it's a benefit or burden, will really depend on the reality of your relationship. And here's their website if you want to read this for yourself, right out of their own act. So this brings us to this new paper burden. Okay, it's a whole new world if you've never been self-employed. So developing good record-keeping habits are crucial, so start early. This is a whole habit that you're going to have to develop if you choose to become self-employed. It is better to learn and study what your obligations are, and we're going to go through some of those here to get you on the right track at the beginning of the year, so when it comes time at the end of the year to do additional paperwork, you have everything in order. It makes your life a lot easier. So we're going to look at what extra paperwork is needed for someone who's self-employed versus someone who's an employee. Well, if you're self-employed, you actually have to fill out something called a Statement of Business Activities. It's a T2124. The forms are available online. We put the current edition within the book to get you going on that if you don't have access to online. And to help you fill that out, they have a Statement of Business Activities guide. So it's something that you can start. If you start early enough in the year to learn what obligations may lay ahead, believe me, you'll be a lot more prepared at the end of the year. And that's T4002. Again, we have the current edition in the binder. So again, it's a lot of additional paperwork, but it's not overwhelming if you start taking it piece by piece. Believe me, if you wait till the end of the year and go, oh, what do I need to know? 1, you won't be prepared. 2, you won't have the proper receipts, documentation you required, and it will feel overwhelming. Okay, so yes, it's new paper burden, but it's not overwhelming it's like this. How do you eat an elephant? 1 bite at a time. Okay, how do you do paperwork for self-employed? 1 day at a time. Develop the habits, and it becomes a lot easier. But here's 3 secrets to lighten that burden. Education, education, education. Again, I may overemphasize education, but I realize if you spend the time up front, it makes life a lot easier later down the road. So this brings us to this meaning of business. I put this in here because what I can imagine is if somebody has been an employee their whole life, they have a hard time imagining that what they're doing could actually be contemplated as a business. Okay? So to give you some education relative to that, let's look at the definition of business, both in the Canada Pension Plan Act and in the Income Tax Act. In CPP, the meaning of business is it includes a profession, calling, trade, manufacture, or undertaking of any kind whatever. Now think of what you do. Is it not an undertaking of some kind? Therefore, could it not fall within the definition of business if you chose it to be such? Okay, let's look at the Income Tax Act. It's virtually verbatim with a few little additions. Business includes a profession, calling, trade, manufacture, or undertaking of any kind whatever. We needed to understand this because, if your whole life has been, i.e. as an employee, it is very hard to contemplate that you can literally do the same thing, but as self-employed, i.e. therefore having your own business, doing that same thing. But is that not also what we saw the purposes for the EI Act was? Effectively, if you're standing beside an employee, effectively doing the same thing, but as a self-employed, they even have provisions for you to access that. So I put this in to help you maybe release that self-imposed limitation because without a lack of understanding of that word. So here we're going to just introduce some of the paperwork that may lay ahead for a typical self-employed paperwork. Here's the top half of the Statement of Business Activities. It's really a 4-page element for the most part, unless you get really advanced or have a very complex issue. The first page is about all you really need for the most part. And what it is, it breaks it down. We'll start looking at, there's all your information, et cetera, but here it goes, the income, salary, commissions, and fees. You add it up, you save all your invoices, you calculate up, there it goes. You minus the goods and service tax and provincial sales tax from there, and you deduct your returns and your allowances. If you have any reserve deductions from last year's, you can put them in there. Any other income, you can put that in there. Then what that actually creates is your gross income for the year. Then you have this calculation of cost of goods sold. For the most part, someone who's self-employed in the service industry won't have an inventory, but if you have an inventory, you start with that. You calculate the purchases during the year. You deduct the subcontracts that you may have hired, which becomes maybe, an available element as self-employed. In your whole scope of being employed, are there parts of your own employment that you could actually subcontract out? Again, you're going to have to look and consider elements like that. Some direct wage costs and other costs. And you minus the closing inventory. And then when you subtract your gross income from the cost of goods sold, it gives you your gross profit. Okay? Then comes this whole section, which needs a lot of contemplation in and of itself. It's on the second half of that page. It's the expenses. This is what attracts a lot of people to try to structure their affairs to be self-employed, even without education. Because what they're looking for is to have access to deduct some expenses. In and of itself is very defined. That's why we provided the guide, so you can actually pre-educate yourself as to what the scope of these expenses are, so you don't place yourself in a situation where you're deducting things that totally don't fall within the intent of it. So it's a very wide range, from advertising, bad debts, fuel costs, management administrative fees for your accountant, etc. Motor vehicle expenses, okay, that requires a lot of record keeping. Okay, office expenses, supplies, property taxes, rent. And rent, again, you really need to study what the parameters of rent are if part of your house is used for an in-home office. Okay, travel, is the travel relative to your employment, etc. Telephone and utilities. So what it does is allow that if your office of your business is a part of your house, a percentage of your maintenance of your house actually becomes relative to your business and therefore becomes a business expense. It's, how you say, it needs to be done very precise, so definitely read the manual into that. And it goes on, so you create your total business expenses. So you have your gross profit minus your business expenses, and it's that amount, if you don't need to go into the other 3-4 pages, it's that amount that gets transferred over your personal income tax at a much lower rate than they deducted at source. And that is what, without education, like I say, people have been attempting to do this because inherently they knew they had a right to do it, okay, but they didn't know how to defend it if it was ever challenged. So with education, you can take advantage of some of these deductions. So here's a few technical tidbits for a payer. Now, where these codes come from is out of what's called the General Index of Financial Information. They're called the Jiffy codes. I put only a few within here, but you can go online, type in General Index of Financial Information, and you can get the whole document itself. But here's 3 that you may want to consider. Code 9060, that's your typical salary and wages. So if you're hiring someone who's an employee, that's where it automatically puts it in, whether your accountant does it or you do it. That's where it generally goes in. But these other 2 becomes more of a decision here. One is 8360, trades and subcontracts. Now traditionally that's where you'll put anybody with contract labor, subcontract labor, and outside labor. For the most part, a lot of people perceive that as those who are not integrated within their business. Okay, and for the most part, that's probably a better understanding of that. But here's this other one. It's called 9110. Okay, subcontracts. It's for contract labor, contract work, and hired labor. That is more of your internal code for someone who looks like an employee, walks like an employee, talks like an employee, but is truly self-employed. There may be something you want to discuss with whoever does your books. Is that more an appropriate code? So you yourself can keep separate of those who are external and those who are internal self-employed elements. Okay? So here's a few sample documents that we want to wrap this course up with. And I want to qualify these. These are sample documents. Like I say, we're not lawyers, we're not accountants, so therefore, to respect all those who are in those professions, we're not here trying to give legal advice or financial advice. But with that said, we also have the right to share our opinions and stuff. And this is what I would do if I was going to choose this option. And so what I've included here is a couple samples that may give you some guidance on where to start and how to start. So here's a sample contract for service. As we saw with the Royal Winnipeg Ballet case law, and many of the ones throughout history, when the contracts had positive announcements in, were clear and precise, and expressed the intention of the parties, that was the end, wasn't it? That was as far as the courts were there only to give effect to the intentions of the parties. So here's what I would do if I were to enter into a contract for service. I would make sure I use clear and unequivocal language. Basically, what it lays out is the start of the 3 parts. There's 3 parts to a contract: the meeting of the minds, the terms and conditions, and the acceptance. Here's the first part. The first section here is the name and address and the date of the company, who's the principal, and the independent contractor, who's the agent. It goes on to say, whereas the principal, under the doctrines of freedom of contract and privity of contract, desire to engage the services of an agent under the terms and conditions of this contract for service, and whereas the agent, under the doctrines of freedom of contract and privity of contract, desire to provide services to the principal under the terms and conditions of this contract for service, now, therefore, in consideration of the promises and mutual covenants contained in this agreement, the parties hereby agree as follows. Now, granted, we did not have to use all those fancy words. Freedom of contract, privity of contract. But why not? Is that not the biggest cause of ambiguities in contract? People trying to save a little bit of ink? Put them in there. That's what I would do, and that's what I've done on here. So here'd be the first clause. Again, and this is as far as this example goes, because everyone in here would have absolutely a totally unique contract for service with their payer than anyone else. So when we looked at all that case law, the only ones that became an issue is where there was a missing element. And what was the missing element? The clear expression of the intentions of the party in relation to the relationship. So here's what I would do. The relationship. This agreement shall be interpreted as creating a principal and agent relationship under a contract for service. Nothing contained in this agreement shall be interpreted as the intention of the principal or the agent to consent to entering into a contract of service or entering into any other relationship between the principal and agent, including without limitation, employee and employer, other than the relationship as set forth and agreed upon under the terms of this agreement. Okay, what did you just see there? Not only did we express it clearly what we wanted, which is called a positive announcement, we even took the extra step on expressing what's called a negative avertment. We took the time to write a clear statement of what was, and for greater certainty, a clarity of what wasn't. So it couldn't be misinterpreted by a third party if somehow a third party gets involved in your contract. So it goes on to say here, furthermore, the principal and the agent agree not to request a ruling from anyone, including without limitation, any federal or provincial government agency in regards to the nature of this agreement or the status of the parties hereunder. What is that? That is, I say, taking preventative measures to protect the sanctity of the contract that you entered into. And you go, well, why bind yourself that way? Well, think about it. If you're going to enter an agreement that you don't understand what that means, maybe you shouldn't enter into it. Maybe you should spend the time to understand that that's a very benign statement. Because if your intention is pure to enter into a contract for service, why would you go make a request for a ruling for a third party to decide otherwise? Or not decide, because at the end of the day, the contract speaks for itself, but waste your time and energy pretending they can decide. So what it is very preventative measure within there, binding both parties with knowledge that, hey, this is one area that we're not going to go into. Okay, so it's expressing that in clear. So again, this brings us back to remember, be silent no more. Take the time to express in clear and unequivocal what it is that you want your relationship to be about. You're the only one who can do it. Okay, there's an advantage in one essence of using template contracts out there. And they may be good as starting formats. Go on the internet, type in employment contracts. You'll find so many things. It'd be, it's just unimaginable, okay? Because they're all unique. But spend the time to find that. But then also take the extra step and say, is this clear and unambiguous? Is this exactly? Does this cover every possibility? So spend the time, because this is what we saw in the Royal Winnipeg Ballet case. Charlotte, the consenting judge, in 16, she goes, there is no contractual instrument that purports to characterize the dancers as employees of RWB or as independent contractors. The Canadian Ballet Agreement is silent on that point. Why remain silent? Okay, so be silent no more. Because when we go on and take a look at a section out of We Door Services Limited versus Minister of National Revenue in 1986, McGugan, who's referencing Lord Wright in Montreal versus Locomotive, the 1947 case, says, the accuracy of the positive announcements in each of the contract that the respondent was acting throughout under the contracts for and on behalf of the government and as its agents cannot be converted. Because the contract wasn't silent, it spoke, and the judges knew what their role was relative to contracts, is to give effect to the intentions of the parties. And if the intentions of the parties is clearly expressed, like the judge says, they cannot be converted. So remember, talk is cheap and it can be converted. Okay, we see this again out of the Royal Winnipeg Ballet. Charlotte in 61. She goes, I emphasize again that does not mean that the party's declaration as to the legal character of their contract is determinative. Okay, so you have this contract, it's silent, you're going, yeah, but. They're saying, hey, because it's not expressed, it's not determinative. Then they got to put you through the test. Nor does it mean that the party's statement as to what they intended to do must result in a finding that their intention has been realized. To paraphrase Desjardins from paragraph 71 of the lead judgment in Wolf, if it is established that the terms of the contract, considered in the appropriate factual context, do not reflect the legal relationship that the parties profess to have intended, well, why didn't they just write it down? Then their stated intention will be disregarded. This is probably where CRA gets that perspective. If the test fails, then we'll go to their intention. But if the test passed, their intention becomes irrelevant. We need to go on And look at what the Supreme Court says relative to that. An actual contract must prevail. Okay, this is out of, again, NJB Enterprises versus Defense Construction. The judge in paragraph 44 goes, the words of the privilege clause are clear and unambiguous. That was the issue in this case. It's relative to a clause of the contract. As this court stated in Cartwright and Crickmore versus McGuinness in 1931, there can be no recognized custom, such as subjecting everyone to a test by a third party, in opposition to an actual contract, and the special agreements of the parties must prevail. Why would they say that? Because they were respecting a fundamental principle, the right to freedom of contract, which is the ability of the parties to agree to the most advantageous bargain between them without interference from the courts. And in the 18th century, there was little restriction placed on this freedom, the philosophy being that men could pursue their interests in the way they saw fit, and the duty of law was merely to give effect to the intentions of the parties. And this position still finds expression today, as we saw in these recent court cases. So here are some suggested terms of a contract. Like I say, it's an inexhaustible list. I would have no idea where to start or stop for any one individual because it's a personal thing. It's your relationship with the payer. Who knows what you want? But all we can do is here's some common ones, and it's very minimalist at the best of it. Is some ideas maybe to get you going. Okay, here's the first one. It's duration. What is the length of the contract? 2, remuneration. How are you going to deal with standard remuneration, overtime, vacation, or other benefits? Remember, benefits are nothing more than remuneration in a different form. So that's a whole subject matter which is very broad and expansive. How about expenses? Now again, some companies say, no, we'll cover this, this, and this. Fine. Make sure that's in there. What if they want you to cover certain things? What if they want you in the middle of the day to run over to another store or do something else? Are you going to be compensated for that? Think of, especially if you've lived in an employment relationship, you know the in and outs of it now anyway, so go through your mind and think of some things that you may want to clearly express. 4 is the responsibilities and the duties. What are they? Make them fair, balanced, reasonable. This is a negotiation. Actually, what you can initially do is draft up where your perspective of it, present it for their input. And it may take a couple times back and forth before both parties come to a mutual agreement, but that is the objective and the goal. Okay? How about a termination clause? Can they never fire you? Okay, do they got to go through a tribunal whether you've done anything bad? Put it in there. Try to be fair, balanced. I mean, if your objective is to engage yourself in gainful employment and you're willing to actually do the work, you should have no problem putting in a nice termination clause. If I goof around, if I drink on the job, if I do drugs on the job, it's immediate termination. If you're not willing to do that, you know, I'll be honest, you may want to stay and exercise your option as an employee. Okay, it's a little harder for employers to get rid of you that way, but I would suggest that you may want to look at exploring the world of taking control back over your life and be willing to put a termination clause that's fair, balanced, and reasonable. Here's another one, general provisions. This could be an inexhaustible list of who knows what. Here's a couple ideas. How about a no active forbearance clause? Again, you can study about what that means. Effectively, here you have this defined set of rules that everything must be in a timely manner, boom, 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 and there's breach of contract. If it's not, well, sometimes it's very hard to live to the letter of the law. And that's what your contract is legal rules you're imposing on yourself. So you put in for some, say, Section 4 to Section 8, there's no active forbearance, which means there's a lot of patience allowed. They're not subject to that timely manner. Okay, so there's one. Another general provision you may want to consider is which provincial or which legislation is a contractual dispute subject to? Is it provincial jurisdiction? And especially in Canada, it becomes very important because Canada is mixed jurisdictions. We're a bi-jural country. We have Quebec, which operates under civil law, which will interpret the contract differently if there's a dispute. And the dispute won't be relative to the relationship anymore. The dispute will be relative to a term in the clause, a breach of contract. The ideal goal is there's no breach of contracts, but nevertheless, what measures are you taking to consider if there is a dispute, which jurisdiction does it actually get heard in? Is it in common law jurisdiction, in which province, or is it in the civil law jurisdiction of Quebec? So there's another general provision you may want to look at putting in. And then don't forget the acceptance, the clause where both parties mutually sign and agree that they're going to bind themselves to these agreements. Okay, like I say, this is such a vague, brief overview of some suggested terms. It's inexhaustible. If you really need some guidance on that, like one, you can contact a private tutor to engage, to really go through that element of it. Two, do your own research, spend time on the internet, download case law dealing with contracts. You'll be amazed at what you will find with just an hours of research relative to the possibilities of employment terms. Okay, so again, for what we did is try to get you going on the right foot. And here where you have to use clear and unequivocal language. Not only did we see where silence was caused a lot of grief, especially Royal Winnipeg Ballet, at the end of the day, nothing really changed for them. Their relationship was acknowledged and respected, but nevertheless, look what it took them to go through. And look what was at risk if they didn't continue down that path of challenging this third-party ruling. So use clear and unequivocal language, especially because in contract law, there's this idea of interpreting agreements. This comes out of Clana versus Jones. It's an Ontario Supreme Court civil suit, 2003. Justice Wilson, he's talking about the law of contract preferendum. What that is, he explains it very well in here. Paragraph 25, he goes, the contract preferendum doctrine, simply put, means that in interpreting documents, ambiguities are to be construed unfavorably to the drafter. Now, for the most part, it would be the self-employed person who's going to draft their contract. So you're going to draft your contract, use clear and unequivocal language. Why? Because if you do have an ambiguity, it depends on what it's relative to. If an ambiguity is found, it goes in favor of the person who didn't draft the contract, or as he says, unfavorably to the drafter. Paragraph 26, he goes, in Eli Lilly and Company versus Novorfem Limited, the justice explained that the rationale behind the rule at paragraph 53, contra preferentiam, operates to protect one party to a contract from deviously ambiguous or confusing drafting on part of the other party by interpreting any ambiguity against the drafting party. Okay, 28, it says, it should be noted that the courts must first find ambiguity in the contract before applying the doctrine of contra preferendum. So again, this is something that, how you say, if you go and search case law, there's a fair bit of cases out there, but not all of them result in ambiguities. So what that is like, if you're going to draft, spend the time to use clear and unequivocal language. And spend the time to really discuss and negotiate that contract that both parties truly understand. It's, so like I say, for the most part, the contract will come from the self-employed person to the employer, okay, to the payer, if that's the term you want to use. So definitely do your best to use clear and unequivocal language. Here's another preventative measure that can be taken. This is what I call a rogue employee. Now, what a rogue employee is actually someone who is self-employed. And I've seen this happen over the years numerous times. I've seen brothers do it to brothers. I've seen businesses virtually get destroyed. What it is, and it's usually done with a lot of people who have low moral integrity and really not educated about the big scope of their relationship in relation to contract. What they do is they'll go onto a site and say, oh, I want to be self-employed, I want to be self-employed, I want to be self-employed. Really what they're saying is, I want all my money and I don't want any deductions at source. That's about the scope of what they're saying. Okay? So, and what happens is the employment relationship goes on, and then what happens after that is they go and run and make a request for a ruling saying, I'm an employee. And now think about it. If you're subject to a test that doesn't even consider your intention, and especially if there's no written contract, who's going to win? They're going to win, and what happens? Boom, the company becomes liable for this concept of a rogue employee. So not only in addition to having it written, that you may want to look at taking some preventative measures. Even in Royal Winnipeg Ballet, Charlot addressed this concept in paragraph 62. It is common for a dispute to arise as to whether the contractual intention professed by one party is shared by the other. Again, especially if it's not written down. Particularly in appeals under CPP and EI, the parties may present conflicting evidence as to what they intended their relationship to be. Such disputes typically arise when an individual is engaged to provide services and signs a form of agreement presented by an employer. Which is, come to the point is, if you're an employer out there and somebody wishes to be self-employed, then have them present the agreement to you. Because why? If they don't use clear and unequivocal language, the doctrine of contra preferendum goes into your favor. Okay? So what it is we got a lot of people getting a lot of hurt because everybody's believing everybody's acting honorably, and only to find that every once in a while you get these rogue employees out there. The employer may have included that clause in the agreement in order to avoid creating an employment relationship. The individual may later assert that she was an employee. She may testify that she felt coerced into signing her consent to the written form of the contract because of financial need or other circumstances. This here is what you're seeing is what caused, from a historical point, the evolution of employment legislation. In the early years, or the courses go into this a lot more, in the early years, the courts perceived an employment relationship to be an inequity of bargaining powers. Okay, and that's exactly what they're saying here. Oh, I was coerced. Oh, I was this. So if you're an employer out there, your position is, if that's your intention, I got no problem with it. You draft the contract, make sure it's clear, make sure it's unambiguous, so the rogue employee can't come in down the road and say, oh, I'm an employee now. Okay, I've seen so much damage caused because of the lack of people willing to put in the time to write the contract. Okay, so here's what we have in the binder as well as a sample of an optional intention affidavit. It's definitely designed as a preventative measure. What it effectively is, it's an affidavit of intention. I'll just quickly read through it and then we'll discuss it from that perspective. It's I, blank of whatever province, affirm and say that I am the affiant of this affidavit and as such have direct knowledge of all the facts herein disposed by me, except where same is stated to be based upon information and belief, in which case I do verily believe the same to be true. Point 1. On the, say, first day of June in the year 2007, with my full understanding and free will, I entered into a contract for service with whoever, be it the employer or be it the employee. This, I believe, can come from both parties to each other. Point 2, as a consequence of my free will decision, the nature of the relationship established under the aforementioned contract for service is not a relationship under a contract of service and therefore is not one of pensionable and insurable employment for the purposes of Canada Pension Plan and Employment Insurance Act, respectively. Now, I want to pause here and make a note. It is possible to be under insurable employment without being under pensionable employment. And we saw that when we looked at the section out of the EI Act. But it is alternatively not possible to be under pensionable employment and not be under insurable employment. Okay, because one dictates the other. Okay, so this is why we use the word and here to connect them both together. So it still preserves the right of someone to seek employment insurance if they choose. Point 3, both parties to the aforementioned contract for service have agreed in writing, remember the clause in the sample contract for service, not to request a ruling from anyone, including without limitation any federal or provincial government agency in regards to the nature of their contract and or the status of the parties thereunder. Point 4, should I, depending on who's drafting it, is the I, at any time request a ruling from anyone, including without limitation, any federal or provincial government agency in regards to the nature of my contract for service and or the status of the parties thereunder, such a request will be done so in contravention of the aforementioned contract and with willful intention of fraudulently obtaining a benefit, be it from a government agent or elsewhere. I affirm this affidavit of my own free will with full knowledge and understanding and free from any duress, coercion, and undue influence. That is a sample of some preventative measures. Is it needed? No. But think about it. If the intention of both parties is what the contract says it is, who would have a problem signing this? Now, does it not give that level of, how you say, putting your money where your mouth is? So what it does in the event that there is a rogue employee out there, i.e. someone who's two-faced, telling you one thing but doing something else later, it gives you a defensive mechanism whether you're the self-employed or whether you're the business employer. Okay, so you may want to look at incorporating that. And like I said, this affidavit of intention, there's no reason that both parties to the contract can have one and give it to each other. And as in the binder itself, it goes down and it has some spaces for witnesses. You know, here's one way of looking at it. If you even want, you can get it notarized. Therefore, you probably only need the one witness because you'll have the stamp. Or you get two independent witnesses. Okay, it's sad that sometimes there's people out there that cause us to take these additional steps to protect ourselves, but they're very easy considering what you will have to do to defend yourself down the road without taking some of these more preventative measure easy steps. Again, like I say, if the intention's pure, this is nothing more than a piece of paper which will shrivel up in somebody's desk drawer. So that brings us back to this fundamental principle. Again, what we discussed this whole course here was learning your options. Again, due to time constraints and the reality of going through every element, what I tried to do was touch on some of the highlighted elements and essences of your right to contract, of principles of interpretation, of what the legislation actually says, and about the importance of taking the time and effort to express your intentions in clear language. In the binder is every court case and a couple more, so you can really educate yourself and really, for your own purposes, go through and correlate to understand that the elements that we use from these court cases, did we express them in the context in which they were expressed? See, that's what you'll find out there is a lot of people rely on case law, but what they do is they'll take case law out of context, try to make it seem some. Go on to CR's website and look at what case law they rely on to support their use of the test. They rely on Royal Winnipeg Ballet. They rely on the weave door. Well, again, in the Royal Winnipeg Ballet, we even saw the dissenting judge question the future validity of that test. So again, do yourself a favor, spend the time to get educated. Hopefully, whether it's summer and a warm night on your porch, read it. Whether it's winter and it's a cold winter night, curl up by a fire and read it. It takes a little bit of time to really build your own confidence in your own understanding. Because at the bottom line, there's this principle that's been around for years, the Westminster Principle. The principle is that a taxpayer can legally arrange his affairs to minimize the tax payable regardless of his motive. It is simply one aspect of the doctrine that taxpayers should be governed by the rule of law, preferably clear and certain laws. So remember, the choice is yours. Really what we have here is 3 choices. Tonight we discussed 2 and really focused on 1. You have the choice at all times to be an employee. It's the easiest relationship to get into. Okay? A lot of times, the vast majority are entering into these employment relations without any written agreement. Fortunately for them, despite their lack of education, there is the Employment Standard Act, which provides generic and default terms to a contract. But even despite that, most employees have never even read that, so they don't even know. I've seen employees being abused by employers who only pick and choose clauses out of the Employment Standard Act they like. And I've just seen it. What good is having laws and rules if nobody even ever spends the time to read them? So behind door 1 is this first choice that you have, a statutory employee. Okay, it's always available. And believe me, because of the generations we've come through, a lot of people are very familiar with this. Okay, but because shift is happening, this whole dynamics of employment relationships is going through dynamic changes as we speak. Your second option is a statutory self-employed. It's more work, especially initially up front, but believe me, once you learn and develop the habits of living self-employed, it's no different than doing the obligations as an employee. Everything has work to it. And the third option is a non-statutory private contractor. That is totally outside the scope and range of this course. That involves all of our other material. It's a natural right. It's based on your natural right. And we looked at this on the You Have Options video. It's the Levine versus Inland Revenue Commission of the House of Lords in England in 1928. It goes on, it goes, "It is trite law that His Majesty's subjects are free, if they can, to make their own arrangements so that their cases may fall outside the scope of the taxing acts. They incur no legal penalties and, strictly speaking, no moral censure if, having considered the lines drawn by the legislature for the imposition of taxes, they make it their business to walk outside of them." Like I said, number 3, the non-statutory private contractor, is a whole nother field of education. But for now, this course just focuses on your first 2 choices, 1 and 2, statutory employee, but primarily statutory and self-employed. So whatever choice you make, may I suggest you choose wisely. So I hope that was educational. It gave you something to think about. It gives you, I hope we leave you with enough resources that you can actually study it yourself, learn it yourself, live it yourself. Like I say, we have associates who can be engaged as private tutors to assist in discussing how to draft a contract, discussing appropriate terms and conditions of a contract, and even, like I say, they may be there to attend as third party to meetings that you may have. Because as, how you say, as the generations have passed now, we now have generations in fields that, in fields of, like, say, accounting, who themselves have never read the statute. And that's why even in the binder I have one article from a tax attorney who explains their perspective of the Royal Winnipeg Ballet outcome. And it basically concludes relatively the same thing. So you may want, you may have to sit down with your accountant and say, hey, look, are you up to date on what the courts have recently said relative to this test, relative to an individual's option, an individual's choice to structure their affairs in respect to the Westminster Principle. So what you want to do is guard yourself from, just because someone has an unfounded opinion, you adopt it blindly. That is what really causes a lot of people a lot of stress. You add a little bit of education. We've done our best to give you the resources to not only educate yourself, but to educate those others who are involved in your situation. And like I say, choose wisely. It's a decision that only you can make. So I hope that was educational, and with the resource material and the reviewing of the course, it'll allow you to make a decision with some knowledge. Thank you very much.